Welcome to the debate. Our focus today is on the fundamental structural future of the mediation profession, specifically its economic model. We're asking whether the field must finally transition fully from its historical culture of volunteerism into a robust, professional, compensated market.
Right. And the central question really is whether professional mediator compensation is an absolute necessity for the survival, quality, and diversity of the field. Or, on the other hand, whether this dramatic economic shift risks compromising the essential accessibility and public service ethos of conflict resolution.
I'll be arguing that compensation is not merely desired, but is an economic and psychological necessity. It's required to ensure consistent quality, to successfully recruit new talent, and to achieve true professional legitimacy.
And I will present the opposing view that relying exclusively on professional compensation risks sacrificing the core values of accessibility and community service and potentially introducing new and frankly deeply damaging market distortions that exclude the public.
Look, the reality is that the current model, the one relying on volunteer or, deeply discounted labor, is structurally unsustainable, and it actively degrades quality. It results in what economists call a market for lemons. If consumers, the disputants, can't easily distinguish a great mediator from a poor one, they just default to the cheapest option, and eventually the low-quality providers drive the competent ones right out of the public market. The barrier to entry it's staggering. We're talking about thousands of dollars in training, certification fees, and annual professional liability insurance, which can cost upwards of $2,500 a year just to get started. This makes unpaid practice an unsustainable cost sink. It's an expensive hobby. Compensation is the only way to combat the brain drain. Highly skilled experts, especially attorneys and psychologists, they face an enormous negative opportunity cost. Sometimes 90% or more when they forgo a $300 to $1,000 hourly billable rate for court-annexed work that pays $75 or nothing at all. We are actively pushing away the talent we need most.
And I absolutely see the cold reality of those upfront costs. I mean, they are a massive barrier, no question. However, the wholesale adoption of high market structures mirroring, say, high-end law and medicine, it threatens the profession's historical roots in community volunteerism and the ideal of offering services pro bono publico. While we have to fix the economic barriers, focusing on high compensation, the $200 to $600 private mediator rate, that will lead to an extreme crowding out effect. It immediately anchors public price expectations far too high, making mediation financially inaccessible for the vast majority of everyday disputes. Furthermore, the argument that payment is the cure for all quality issues, it rests on a flawed psychological concept, the price-quality heuristic. This is the assumption that high price signals high quality. Quality standards should be driven by rigorous, enforceable certification and licensure to protect the public, not just by market signaling. If we chase high fees, we risk replacing one form of exclusion, the wealth required to become a mediator, with another, exclusivity driven by high fees for the client.
The challenge is that without revenue exceeding these substantial fixed and startup costs, professional infrastructure just cannot exist. We can't build the administrative or support systems necessary for a mature field. I mean, think about modern complex cases, commercial disputes, specialized intellectual property matters. The only way to attract the necessary subject matter experts for these high-stakes conflicts is through market rates. Corporate clients prefer paid specialists because the cost of a failed settlement far outweighs any mediator's fee. Their actions demonstrate that they require payment as a proxy for competence in these highly technical disputes.
I agree that specialized, complex disputes require specialized compensation, but we are debating the core structure of the entire field, right? If mediation follows the trajectory of the legal profession, which itself evolved from a system of service based on honoraria, the focus should be on formalizing the ethical obligation of service. We need to ensure every professional dedicates time to low-cost or free cases, rather than simply monetizing every single interaction. Furthermore, if the court system utilizes free or near-free labor, it fundamentally distorts the entire market. It actively destroys that missing middle tier, the competent, affordable mediators, which means your highly compensated model benefits only the ultra-high-end super mediators, while the public is left with the lowest quality free option.
I'm just not convinced that focusing on ethical obligation alone is sufficient, because unpaid labor is inherently discriminatory. It undermines our long-term goals. Your point on the missing middle is a powerful one, but we have to ask who is left to fill that gap. Unpaid work perpetuates what's called the retiree problem, where the demographics are heavily skewed toward older, wealthier professionals with existing pensions who can absorb the overhead and the debt. Payment is the essential mechanism that allows younger, diverse practitioners who are often burdened by, crushing student loan debt to view mediation as a viable career path. Payment is the only tool that truly addresses the insidious wealth barrier that stifles cultural competence and prevents the profession from reflecting the community it serves.
That is a compelling argument regarding the lack of diversity and the economic reality for younger practitioners. I'll grant you that. However, let's consider the psychology of payment itself. While payment creates skin in the game, that sunk costs to leverage for some parties, it also risks devaluing resolutions reached in free settings. Even more importantly, the psychological benefit of a settlement reached through a volunteer or a low-fee system, one viewed as a public good, might provide a different kind of endowment effect. That is, a stronger sense of ownership and commitment over a process that felt altruistic rather than, financially coercive.
I think that perspective undervalues the reality of high-stakes litigation. Behavioral economics shows that free services are often irrationally devalued. These high-stakes litigants overwhelmingly prefer private paid mediation precisely because they associate high fees with competence and tenacity. This is particularly true in what are called credence goods, services where quality can't be assessed even after consumption. When a mediator's time is valued at zero in the volunteer model, their advice, their reality testing, their process management, it may be dismissed more easily by counseling clients than if that same advice were purchased at a premium. The financial contribution serves as a crucial practical lever for the mediator to break impasse, proving the client is genuinely invested in the outcome.
But the comparison to legal pro bono is fundamentally flawed in its structure. Lawyers benefit from a state-sanctioned monopoly on legal representation, and their pro bono work is usually subsidized by large firms that can afford the overhead. Solo or small firm mediators who lack that monopoly or that firm safety net absorb the entire economic cost themselves. Instead of abandoning the concept of low-cost accessibility entirely, we should be focusing on dismantling the market distortion caused by court programs that cap fees at artificially unsustainable rates, such as $75 an hour. The problem isn't the existence of public service, it is the institutionalized price suppression.
Sustainable practice is intrinsically linked to compensation. Mediation is profoundly emotionally demanding. The repeated engagement with high conflict leads to well-documented phenomena like compassion fatigue. Without the financial reward acting as a necessary buffer against emotional stress, low financial satisfaction just accelerates burnout and high turnover. And high turnover directly degrades quality because it prevents the accumulation of institutional knowledge and mastery. Furthermore, a consistently paid model establishes clear contractual accountability. It forces the standardization of practice, which market discipline demands from clients who are paying significant fees.
It's an interesting point about burnout prevention, but I would frame the incentive issue differently. While compensation buffers stress, the drive for high income could dangerously shift the mediator's incentive structure away from resolution and toward maximizing billable hours, which is the very critique so often leveled against litigation attorneys. And if the goal is truly accountability, payment isn't the right mechanism. Legitimacy and protection for the public should be achieved through rigorous licensure and regulation processes that ensure consistent standards regardless of whether the service is free, low cost, or high-end market rate.
The source material provides compelling evidence that the volunteer model is a structural liability that prevents the field from maturing. For mediation to achieve legitimacy, to attract the necessary expertise, escaping that huge negative opportunity cost penalty, and to ensure a diverse pipeline of future practitioners, it must embrace robust fee structures. Payment is not a luxury. It is the necessary financial infrastructure for quality, for stability, and for professional maturity. It's what allows mediation to move beyond its perception as a hobbyist pursuit and establish itself as a true pillar of the justice system.
While the economic analysis of the unpaid model is sobering and the need for structural change is clear, the critical challenge remains ensuring that this necessary push for professionalization does not sacrifice the foundational public service mission of mediation. We must avoid anchoring the price of conflict resolution so high that we exclude the vast majority of disputes and the very populations the service was originally intended to serve. The true path forward, it requires balancing economic viability with enforceable standards, ensuring the expertise is accessible and not just exclusive to the wealthy.
The material clearly demonstrates an intense tension between economic rationalism and historical altruism, a tension the mediation community must resolve decisively to determine its ultimate role in the justice system.
And there is certainly much more to explore in this material as this evolution continues.